Hi, so welcome back to Intellectual Property. In today's segment of our trademark section of the class, we're going to be talking about trade dress protection and how it works in practice, in particular in relation to related forms of protection like product packaging as well as product features, as we discussed in our last class. So previously, we talked about the color of a dry cleaning pad and whether that particular color could be protected as a mark. Well, what we were talking about was trade dress protection, right? Trade dress protection is just a way of talking about a mark that isn't a word or a logo, right? So an aspect of a product or service that conveys information about source kind of in the aggregate, right? So a word or a logo or particular feature of a product design or marketing might provide very focused information to consumers about the source of a product or service. Trade dress is kind of looking more generally at at the kind of overall image and appearance of the product, although it could certainly be focused on a particular feature or quality. Frequently, it relies on the kind of total experience of the product or service in order to differentiate that product or service from other related products or services and communicate information about the source of the product or service to consumers. And the question is, when can and should trademark protect trade dress? How should we evaluate whether a particular trade dress claim is valid? And how should we evaluate whether or not an accused trade dress is infringing? Okay. So one of the cases you read for today's class is the classic 2 Pesos v. Taco Cabana case. What happened there? Well, Taco Cabana was a San Antonio-based taqueria chain, right? So Taco Cabana was doing business in San Antonio for a number of years, opened multiple stores, started expanding, and during that time, another taqueria chain opened in Houston called 2 Pesos. Well, by the by, eventually Taco Cabana became popular enough and expanded sufficiently that it started opening its own restaurants in Houston. So now all of a sudden, Taco Cabana and 2 Pesos are going head to head in the same geographic area. And what happens? Taco Cabana brings a trade dress infringement action against 2 Pesos. Now, specifically, this is a unregistered trademark action, right? In other words, Taco Cabana hasn't registered its trade dress, the overall appearance of its restaurants with the trademark office, but it doesn't need to. Right? You can bring a trademark infringement action on the basis of an unregistered mark, including unregistered trade dress. This is not uncommon, right? Because trade dress can be pretty hard to register, right? In other words, how do you go to the trademark office and effectively explain the sort of intangibles that constitute the trade dress in a way sufficiently definite for it to be registrable by the trademark office? But one of the concerns or one of the limitations of the unregistered trademark claim that they're making here is that effectively it's got geographic limitations that a registered mark wouldn't have. In other words, in order for Taco Cabana to bring this unregistered trade dress claim against 2 Pesos, they have to show that they're actually competing with each other and that therefore there's a risk of actual confusion among consumers. So until 2 Pesos, or rather until Taco Cabana had moved to Houston and started competing with 2 Pesos, that risk didn't exist, and therefore the basis for the action presumably didn't exist or would have been a lot more difficult to bring. In any case, case goes to a jury and is decided by the jury on the basis of a number of specific questions that the jury asks or is asked to answer that the judge then uses the answers in order to determine the outcome of the case. And two elements of the jury's findings are especially important, right? First, the jury says that Taco Cabana's trade dress in the appearance of its restaurant is inherently distinctive, but it also finds that the trade dress of Taco Cabana's restaurants hasn't acquired secondary meaning with consumers, right? So it's saying that it's inherently distinctive. In other words, it's inherently communicating information to consumers, but also says it doesn't actually currently communicate information about source to consumers. And then finally, it finds that there is a risk of consumer confusion based on trade dress infringement. So what are we talking about when we talk about Taco Cabana's trade dress? Well, according to the court, that could include all manner of different things, right? The appearance of the restaurant as a whole, the nature of the sign, the sort of floor plan, decor, menu, blah, blah, blah. All the aspects that go into running the restaurant constitute the trade dress of the restaurant. That's what, or the chain, that's what Taco Cabana is saying that 2 Pesos has infringed on. In other words, Taco Cabana is essentially saying, look, we've developed this taqueria chain, and 2 Pesos is horning in, right? They're taking advantage of the distinctive taqueria environment that we've developed, and that's improper. Okay, well, here's an image of an actual Taco Cabana from the time in question. I leave it to you to evaluate whether or not this is particularly distinctive, either as a restaurant as a whole or as an example of a particular taqueria. In any case, the question comes before the Supreme Court on a very specific question, right? Namely, is the jury's finding consistent with finding that Taco Cabana's trade dress is actually valid in the first place? After all, if the trade dress is inherently distinctive, how can it be that it hasn't acquired secondary meaning? In other words, to say it hasn't acquired secondary meaning is to say it's not actually distinctive. So how can it be inherently distinctive but not actually distinctive at the same time? 2 Pesos says there's an inconsistency here that has to be reconciled, and it should be reconciled on the grounds that, well, Taco Cabana apparently hasn't managed to acquire distinctiveness in its trade dress, and therefore they shouldn't be able to pursue it. The Supreme Court rejects that contention, however. Supreme Court says, look, we think it's consistent with trademark policy to find that trade dress protection can be inherently distinctive. We don't want to disadvantage people who invest in the generation of trade dress by saying that they can't claim inherent distinctiveness. It would be unfair to allow others to start taking advantage of it merely because it hadn't yet developed distinctiveness. And who's to say how long developing distinctiveness might take? Right? So we're not going to limit it in this way. And importantly, 2 Pesos itself didn't argue that trade dress couldn't be inherently distinctive. In other words, they conceded that, well, maybe trade dress protection should be inherently distinctive or is inherently distinctive in some circumstances, but there should be a time delimitation, right? You should be able to actually show distinctiveness after a certain period, or else trademark protection shouldn't continue. And in a kind of more formalist move, the Supreme Court essentially said, no, we're not going to impose that kind of limitation on the scope of trade dress protection. Notably, the Supreme Court explicitly didn't ask whether the Taco Cabana claimed trade dress was functional in the relevant sense. And we might ask what it means for trade dress to be functional, specifically in this particular context. In other words, to the extent that Taco Cabana's trade dress is conveying information to consumers, what kind of information is it conveying? Right? Is it conveying information to consumers about the particular restaurant that they're going to? Or is it conveying information about the nature of the restaurant and what to expect about the kind of food, service, and experience that they're going to have, right? Could we distinguish between those two in terms of whether or not they're communicating information in a trademark way? Right? In other words, is the decor, are the things that Taco Cabana is claiming telling consumers, telling guests, telling customers that this is Taco Cabana, or is it telling consumers this is a taqueria, right? And if it's telling consumers this is a taqueria, is that the kind of thing that trademark law can or should be protecting in the first place? Now, the Supreme Court also says that it finds no reason to require secondary meaning for trade dress, right? So this is the kind of argument that Two Pesos is essentially making, saying like, look, if you want to bring a trade dress infringement claim, you ought to have to show that the trade dress in question is actually communicating source related information to consumers, that it's actually communicating trademark type information to consumers. And the Supreme Court says, no, we're not going to find a requirement of secondary meaning, right? We don't see a good policy point for doing that. And in effect, by saying that there could be inherently distinctive trade dress, Two Pesos is kind of conceding that point. You might ask, is that a concession they should have made? Why might they have made that concession? Might we have concerns about the outcome of the case on that basis? And more than that, is this case consistent with Qualitex, right? After all, in Qualitex, the Supreme Court says that the color of a particular product cannot be inherently distinctive, and therefore the claimant has to prove that the color of the product is actually communicating information about source to consumers, right? And can't claim inherent distinctiveness on the basis of the color alone. Why should the decor of a restaurant be different, right? I mean, should trade dress ever be found to be inherently distinctive? What would it mean for trade dress to be inherently distinctive? How do we know? Why do we have inherent distinctiveness in the case of other kinds of marks in the first place? Is it something kind of inherent to the marks themselves, or is it more of a prediction about how consumers are going to understand the mark in question? And if it's a prediction, can we legitimately make those kinds of predictions about trade dress in the same way that we do for word marks and logos? In other words, how do product features and qualities and service features and qualities actually go about communicating information about source to consumers? And is inherent distinctiveness a concept that's actually consistent with our policy goals in relation to this kind of mark? Okay. Let's also think briefly about the Walmart v. Samara Brothers case. What happened here? Samara Brothers, they make children's clothing, a relatively successful company making kind of high-end children's clothing. Walmart sees that the Samara Brothers clothing line is successful and goes to a manufacturer in China, essentially says, we'd like you to knock off kind of versions of the Samara Brothers clothing. You can change things up, change things around, but we want basically the same kind of idea. One of Samara Brothers customers then comes to them and says, hey, wait a minute, we saw your clothing selling for less at Walmart. What gives, right? Why are you charging us so much extra for this product if Walmart's able to sell it for cheaper? And Samara then realizes, of course, that Walmart has been knocking off their products and brings a claim against Walmart. Well, what's the problem here? The Supreme Court sort of looks at this tension between Two Pesos v. Taco Cabana and the Qualitex case and says, how do we think about product features of this kind? In other words, can the kinds of claims that Samara Brothers is bringing actually constitute a protectable mark, right? What do they actually have to show here? Do they have to show distinctiveness or not? In other words, can they claim that the product design is inherently distinctive and therefore there's no need for them to show secondary meaning? Or is there going to be an obligation for them to show secondary meaning? And it says the latter, right? Essentially, it says, look, product design is the kind of thing where it's too close to being functional, right? And there's a need for competition to produce similar products. Therefore, if Samara Brothers wants to bring a trade dress infringement claim on the basis of the appearance of its clothing, it's going to have to show that the clothing is actually communicating information about source to consumers. In other words, Samara Brothers has to show that the appearance of its clothing says Samara Brothers to consumers, not children's clothing to consumers. And if and only if it can do that, will Samara Brothers be able to proceed in its action. Under the circumstances, it doesn't look like it can. Well, why is the court comfortable with that? It says, look, too close to functionality. There's alternative methods that Samara Brothers could use for protection, including design patent protection for the design elements, including potentially copyright protection for some of the elements as well. It doesn't need trademark protection under the circumstances, and therefore we're going to find that secondary meaning is required in order to bring a claim. And then it makes another interesting distinction, right, between product design and product packaging. And it says, well, product design isn't and can't be inherently distinctive. You have to show secondary meaning. But that's not true for product packaging, right? So product packaging is primarily intended to communicate information about source to consumers. Therefore, we find that product packaging could be inherently distinctive, even though product design is not necessarily inherently distinctive. And then it sort of waves its hands around a little bit, saying like, well, is it hard to distinguish between the two? Well, maybe yes, maybe no, but things are hard all the time, and we figure it out. And how do we square that with 2 pesos v Taco Cabana? Well, maybe the kind of trade dress at issue in 2 pesos was a form of product packaging, or as the court says, a kind of tertium quid, something else that sort of also falls into the category where inherent distinctiveness is fine. We're not going to worry about it under the circumstances and figure it out on the back end. Notably, Samara later prevailed in another action against Walmart for copyright infringement on the basis of copying the particular design elements of its children's clothing. I ask you whether or not you think that copyright infringement claim was correctly decided, right? I know the images are a little small here, but comparing the two, do those look like infringing images to you? How broad should copyright protection of the copied elements of Samara Brothers clothing be? Is there a risk of consumer confusion in a copyright sense between the two? And should the court's reliance on should the court have relied on Samara Brothers registration in order to find that the copyright was valid and the infringement should have gone through? Or maybe do you think there could have been reasons why a jury might have been inclined to find in Samara Brothers' favor and maybe fudge a little bit on the copyright infringement claim?